People against Jamon Jordan Higgins, 25B716906FY. Detective, your name?
Good morning, Your Honor. Crystal Tulas, Detective, Brownstown Police Department.
Raise your right hand, please. You solemnly swear or affirm that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
Your Honor, on May 24th of 2025 at approximately 3:33 a.m., Sergeant Mott was dispatched to the intersection of Hickory and Willow Grove in Televalley in Brownstown Township for a possible traffic accident involving a pedestrian. While en route to the accident, dispatch advised that there was also possibly an abduction of a female involved with the traffic accident. Upon arrival to the scene, Sergeant Mott located who was later identified as victim Jordan Damron, lying on his back, and a witness, Mackenzie Damron, standing over him. The victim, Jordan Damron, was bleeding from his mouth and was unresponsive, but was still breathing. The Brownstown Fire Department arrived at the scene at the same time as Sergeant Mott and began treating him. Sergeant Mott spoke briefly with the victim, Jordan Damron, while he was being treated by the Brownstown Fire Department. Jordan Damron is the brother of the witness that was standing over him, Mackenzie Damron, and I'm sorry, that is his cousin, and he is the brother of another witness to this incident, Carly Damron. Sergeant Mott asked Mr. Jordan Damron if he could tell him what happened. Initially, victim Jordan Damron told Sergeant Mott that he could not tell him what happened, but stated that Jamon Jordan Higgins had a gun. Victim Jordan Damron then told Sergeant Mott that Mr. Higgins had assaulted him, but was not sure if Mr. Higgins had used the gun to assault him. Sergeant Mott asked the victim Jordan Damron to describe the handgun, but the victim Jordan Damron was unable to do so. Sergeant Mott asked victim Jordan Damron if he was certain that he was assaulted with a handgun, and victim Jordan Damron stated he was certain it was a handgun because Mr. Higgins had the handgun while victim Jordan Damron came outside. Victim Jordan Damron also stated that Mr. Higgins was waving the handgun around when Mr. Jordan Damron came outside. Prior to speaking with victim Jordan Damron, the Brownstown Fire Department personnel were attending to his injuries in the ambulance, and they advised that the victim had injuries to the back of his head and to his ear. Sergeant Mott further observed that Jordan Damron had a swollen face and blood coming from his mouth. Sergeant Mott also spoke to witness Mackenzie Damron about this incident. Witness Mackenzie Damron stated that Mr. Higgins came to her residence located at 23697 Hickory Drive in Brownstown prior to this incident occurring to pick up Carly Damron, who is Mr. Higgins' girlfriend and the mother of his children. Witness Mackenzie Damron stated that Mr. Higgins is a very jealous person and began arguing with Mackenzie Damron and Carly Damron. She stated that victim Jordan Damron came outside at some point during the argument. Mackenzie Damron stated that she began to walk away from the incident to get away from Mr. Higgins, but as she entered the residence, she turned around and came back to where the argument was taking place outside, where she located victim Jordan Damron lying on the ground on his back, bleeding. She stated she did not see the assault, but she did see Mr. Higgins running away from where Mr. Jordan Damron was on the ground bleeding. She stated that Mr. Higgins got in an unknown vehicle and fled the area. Witness Carly Damron, who is the sister of victim Jordan Damron, was also interviewed. She stated that she had been at the bar earlier in the night with victim Jordan Damron to celebrate his birthday. She stated that she and victim Jordan Damron went to witness Mackenzie Damron's residence at 23697 Hickory, and that upon arrival, or shortly after their arrival, Mr. Higgins showed up at witness Mackenzie Damron's residence. Witness Carly Damron said that Mr. Higgins knew where she was because he tracks her location with her phone. She stated that after they arrived at Mackenzie Damron's residence, Mr. Higgins showed up and began honking the horn of his vehicle for Carly Damron to come outside. Carly Damron stated that she went outside so that she could leave with Mr. Higgins because she knew that if she didn't, that the situation would escalate further. Carly Damron stated that when she went outside, witness Mackenzie Damron followed her. Carly Damron stated that Mr. Higgins and Mackenzie Damron began arguing, and during the argument, Mackenzie Dameron began to leave and go back inside the residence. Witness Carly Dameron stated that she got into defendant or Mr. Higgins' vehicle, an unknown silver Chevrolet. She said that once she got into the vehicle, Mr. Higgins also got into the vehicle, but then got back out, and that when Mr. Higgins was getting back out of the car, she heard Mr. Higgins chamber around in Mr. Higgins' gun. She stated that she saw Mr. Higgins walk towards victim Jordan Dameron, but did not see what occurred between the two of them. She stated that Mr. Higgins got back into the vehicle, and Mr. Higgins told her that, quote, "I knocked him out." Witness Carly Dameron went on to state that she does believe that Mr. Higgins would have used a handgun to assault victim Jordan Dameron, but she was uncertain if Mr. Higgins used the gun to assault Mr. Dameron during this incident. Sergeant Mott requested that dispatch run a check of Mr. Higgins to determine whether or not he had any registered firearms. The results did show that Mr. Higgins had a CPL and 2 handguns registered to him, a Springfield Armory XD9 16-shot semi-automatic pistol, and a Keltec PF9 9-shot semi-automatic pistol. Following the initial investigation, Officer Walker traveled to Coral Trenton Hospital, where he photographed victim Jordan Dameron's injuries. While at the hospital photographing those injuries, Officer Walker made contact with witness Anna Dameron, who identified herself as victim Jordan Dameron's mother. Anna Dameron stated that following this incident, her daughter Carly Dameron called her and told her that while she was still in the vehicle with Mr. Higgins, Carly Dameron told Anna Dameron that Mr. Higgins had struck victim Jordan Dameron with a baseball bat. Witness Anna Dameron stated that she heard a male whose voice she recognized as Mr. Higgins in the background state that he did not hit him with the bat, he hit him with his gun. I was subsequently assigned to provide additional investigatory services in this case, and I spoke to witness Anna Dameron, victim Jordan Dameron's mother, by phone. During this conversation, witness Anna Dameron had reported that the doctors treating victim Jordan Dameron diagnosed him with a subarachnoid brain hemorrhage and 2 fractures to his jaw. Witness Anna Dameron reported that her son was also experiencing pain in his ears and that his jaw had to be wired shut due to the jaw fractures. Witness Anna Dameron also expressed that the doctors had indicated to her that the injuries were likely caused by blunt force trauma from a foreign object, potentially a firearm. They also provided several different screenshots of text messages. I was unable to interview Jordan Dameron directly due to his jaw being wired shut.
You know what? I've heard enough to authorize here. I'm going to indicate that you sent the complaint over and dated it yesterday. I'm changing the date to today since we did the signing on record today, August 12th, as opposed to yesterday. Based on your sworn testimony, I find that the crimes of assault, intent to do great bodily harm less than murder, and felony firearm were committed. There's probable cause to believe those crimes were committed by the defendant. I'm unauthorized. I've signed the complaint and the warrant, and we'll put that warrant in the lien. Thank you very much.
Thank you, Your Honor. Have a good day.
Thanks a lot. Okay, so Community Financial versus Adam P. Tilley.
Your Honor, there is no service on that, but we were checking this morning, so that one is not going to go.
Okay.
It was a discovery subpoena.
All right. Versus Adam P. Tilley, 2402248. I'll just indicate service not accomplished, reschedule. All right. Midland Credit versus Tanel Gardner, 2500576. All right. Ms. Gardner, your name, please. You're going to have to unmute.
Hi, Your Honor. Tanel Gardner.
Okay, you need to keep your voice up. Get nice and close to that device for me. You're muffled so slightly. Who is here for the plaintiff on this one? Is anybody
Mr.
here?
Monroe, sorry, he's unmuting right now.
I'm there now, Your Honor. David Monroe, P18081.
Do you guys want to go into a breakout room and talk?
Been there already, Your Honor.
No resolution?
No resolution.
I think it's pretty clear that she has the right to have the case arbitrated, don't you, Mr. Monroe?
Absolutely. The issue is not whether she has the right to have it arbitrated. It's a question of who has to pay for it.
Well, do the documents, indicate? I didn't.
In fact, Your Honor, they do not.
Your Honor, as I was reading and did my research, I looked up the clause.
Nice and loud, ma'am. Nice and loud,
I'm
please.
sorry, can you hear me now?
Now I can hear you better.
Okay, I had to get closer. I did my research and looked up the contract, and it states that if I can't pay for the arbitration fees, which I can't, that I would have to sign a written request stating that I can't pay. And
Tell me what provision you're on in the arbitration agreement, ma'am.
it says the
Tell me what
location.
paragraph, what number?
I'm sorry, it's number 8. 8. Location and cause.
Do you work?
No, I don't.
Well, counsel, I don't know that I really need to address that. It seems like that's going to be something taken up with the Arbitration Association. So all I'm going to do here is order that the case be dismissed without prejudice. I'm not going to stay the proceedings. There's no reason for that. For the reason that the parties are to submit to binding arbitration in accordance with the arbitration clause from the Community Bank cardholder agreement. So I'm just going to ask you to submit an order. You can file that, and the Arbitration Association can take that up and decide whether or not she can pay and who's to pay the fees. I think that's something where I'm putting the cart before the horse. She says she doesn't work. There is a provision here that if you can't pay, and put that in writing, I guess I can quote it, we will pay them for you. Parties shall pay filing, administrative, and arbitrator fees in accordance with the administrator's rules and applicable law. However, if we receive a written request personally signed by you stating you cannot afford to pay your portion of said fees, we'll pay them for you. So I don't think this is anything for me to address. So I'm simply going to ask you to submit an order. Okay, I got to have somebody muted here, whoever it is.
I'm sorry, Your Honor. I'm on 2 cases at the same time.
That's okay. So I'm going to ask you to submit an order dismissing the case for the reason, and without prejudice, for the reason that the parties shall submit to binding arbitration in accordance with the cardholder agreement.
With respect, Your Honor, I disagree with that ruling because arbitration, according to the contract, is optional on both sides, and plaintiff made its option to bring the case before you. So if she wants,
well, that doesn't mean so. If you make the okay, so you can point out the provisions of the agreement if you want. That means that you're completely dismissing the option of the defendant to go to binding arbitration, aren't you? Well, you can't say it's optional, plaintiff filed here, so therefore it has to remain in the 33rd District Court. If you want to point out the paragraph, I'll be happy to read it.
Your Honor, it's not a question of what the contract says that way. The question is, once it's been filed before you, she has the option to remove, but if she wishes to remove, she bears the burden.
Tell me where you see that in the contract. What provision?
Doesn't say, Your Honor, it doesn't say either way. It just says both parties have the option. We've already spent some money filing the case before you.
Wait a minute, slow down. I need you to point to the paragraph here. I didn't see any objection. Maybe I'm wrong. Maybe I misread your response. You're saying it's not cost effective. I didn't write the agreement. The cardholder wrote the agreement. If they don't want to have that in the agreement, they better take it out. Either party may elect to move the case to arbitration. And I've got a provision saying if she can't pay the fees, she can submit that in writing. If you want to take a minute and look at this, I'll be glad to listen to you, counsel, but I don't see it. It might be more cost effective.
Judge, it looks like we may have lost him.
I don't know what to tell you. Ma'am, stay there. I'm going to let him point out the agreement. Don't go anywhere, please. I'm going to recall that as soon as he comes back in.
Okay, thank you, Judge.
Synchrony Bank, Synchrony Bank versus Virginia Plemons, 2502214. Good morning, Mr. Filkins, your name?
Yes, good morning, Your Honor. John Filkins, P70263, appearing on behalf of Virginia Plemons, who's appearing remotely by Zoom as well.
Ma'am, your name? You have to unmute. Who is here for Synchrony Bank?
Judge, I have not had anyone check in for Synchrony, and I called and was on hold for 5 minutes trying to get a hold of someone.
It's always these firms out of other states, you know that? I don't know what to tell them. Maybe they shouldn't be practicing law here if they're not going to show up. I mean, what are we supposed to do? Well, I mean, they've waited. It's 9 o'clock. The case was scheduled for 8:30. I'm going to go on to a couple others and then I'm coming back and going to see if the lawyers showed up, but we're not their secretary. This is a Wisconsin law firm. That's fair. If they're licensed here, they can practice, but they still have to practice like everybody else practices, not like they want to practice. LVNV versus Vicky Essenmacher, 2502703.
Good morning, Your Honor. Stephen Couch, P75833, appearing on behalf of plaintiff.
Good morning, Ms. Essenmacher. Your name?
Vicky Essenmacher.
Good morning.
Good morning.
I don't know what to say. Did you guys talk about this? You're saying there was fraudulent use of a credit card, ma'am?
Yes. Yes. My husband and I were in the hospital both with COVID and the Trenton Beaumont at that time. I gave my husband my ID, my insurance card, and my social. He ended up passing away. I went back to go get my credit cards and all his belongings and everything he had. And they said that it went to the funeral home, and the funeral home said it went to the hospital. So it went back and forth. And then what ended up happening is I had to file a police report, which I did, and gave this credit card company 2 or 3 different occasions, which they said they were going to take care of, but never did. So I've been going.
Was this a joint credit card that you and your that your husband owned together?
No. What happened was about 4 or 5 months after he passed away, I started getting a bunch of different credit cards in his name and my name, and I'm like, what the heck is going on here? So I was told I should go file a police report. So when I went down to Trenton to do so, the gentleman, the police officer there, told me he had actually arrested 2 janitors for stealing from people. So that was at the time what happened. So I gave them the police report, and several times they told me a supervisor would call me back, and no one ever would. And then when I would talk to one, it was constantly just a runaround. And then the balance also said it was only a 500 limit, and they're trying to charge me 3,500. So I'm it's just been really stressful.
Mr. Couch, have you looked into this at all?
Your Honor, I'm hearing today on behalf of Counsel Record. My understanding from what they've provided to me is that the account was opened, that there were 1 or more payments made on the account, and then at some point the payments stopped and it went into collections. That is the extent of the information I have on this one, I'm afraid.
Well, I can't resolve this today. I understand what you're saying, ma'am. I'm going to give you guys discovery. Now, I want you to understand that you're going to have a difficult time here, ma'am, representing yourself. I understand it may be cost prohibitive to hire a lawyer,
Yes.
but I can't appoint lawyers on civil cases of this nature, okay? I don't have the authority to do that. So what I'm going to do is I'm going to give you guys discovery. Discovery is the exchange of information. If they have documentation that you want, you can request it in writing. If you want to send them written questions, you can do that as well. Okay? I'm going to go ahead, Mr. Couch. What's your P number, sir?
75833, Your Honor.
Okay, thank you. So, ma'am, I'm going to go ahead and give you some dates. So I'm not going to order ADR on such a case. There's just no reason for that. I'm going to give you guys discovery for a period of 60 days. You can conduct discovery here. That's the exchange of information, again, as I said, until October the 17th. October the 17th. No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. I'm not going to order a settlement conference. So I'm going to put down 1/2 hour. You have to file your witness list by September the 17th. September the 17th. And I'm going to give you guys a trial date here momentarily. So Jennifer, why don't you, and I'm going to cover a couple other things with them. Why don't you give me a date in the latter part of November, please? So Ms. Assenmacher, you didn't really answer the complaint appropriately. You're supposed to go through each allegation and either admit it, deny it, or neither admit nor deny for lack of sufficient information.
Okay.
You can't just write in letters here. I'm not going to make an issue of it, but if he files a motion for a more definite statement, I'm going to grant it. Okay? So that's the best way I can put it.
Well, I will tell you the reason that some of the payments were made was because I was just paying everything at the time. I wasn't really.
Let me ask you a question.
Yeah.
Did you review the charges?
Yes, and none of them. There's a lot of them were out of state. I wasn't out of state. I was on oxygen in my home. I couldn't even leave my home or drive, let alone worry about credit
Mr.
cards.
Couch, I've been doing this a long time. I tend to believe her. I'm not suggesting you should dismiss your case now. I am suggesting that you should look into this, please. Okay? Send him, do you have the police reports, Mr. Couch?
I don't, Your Honor, but I will.
Can you send
I will forward
those
that
to-
along.
You have the police reports, right, Ms. Assenmacher?
I don't because I sent the original, but I can go there and get another if I have to.
I'm going to let you two talk about this, conduct discovery. I'm going to give you a bench trial date, and we're going to go from there. But it does seem to me like she's being honest and sincere here. You don't have to file a trial brief when it comes to that. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. Go ahead, Jen, give me a date at the latter part of November or the first week of December, please.
Judge, we can do November 17th or December 1st, which would be better.
Let's do December 1 at what time?
10:30.
10:30, and we're going to set others at 10:30 because I have a feeling this will resolve. Okay? So 10:30 so you can write that down. We're going to prepare a pretrial order. We're going to send it to the two of you, and we'll go from there. Okay? Anything else, Mr. Couch, on this one?
No, Your Honor, thank you.
Ma'am, anything else? Any questions or anything? This
No,
is
I
just,
appreciate your time. Thank you so much.
this is just a pretrial right now, okay?
All
All right, thank you very much. Midland versus Gardner, 2500576 GC. Mr. Monroe, your name again?
Yeah, David R. Monroe, P18081, Your Honor, and I apologize. My machine kind of fell out on me and I'm back now.
It's fine. Ms. Gardner, where are you at? There you are, ma'am. Your name again?
Tanel Garner, can you hear me?
I can.
Okay.
All right, now, counsel, I don't want to hear anything other than you telling me what portion of this says that she can't have the case removed. It's at the option of either party. You even said it in your brief.
I agree, Your Honor. The question is, who pays for the arbitration?
I'm gonna let the Arbitration Association deal with that. I just read you the provision.
I understand that. What
If
I'm
she's,
saying,
I don't have a letter from her. Look, you guys wrote the contract. If you wanted to say that and it's your client wrote the contract, she didn't write the contract. That goes back to contract 101. If there's a provision that's ambiguous, it's resolved against the drafter of the contract. That's the extent of my order. Please submit an order that's. Counsel, you got to turn that off for me, please.
I just did, Your Honor.
Thank you. Submit an order. Case
Okay.
dismissed without prejudice for the reason that the party shall submit the binding arbitration. Thank you.
All right, thank you.
Thank you.
Thank you. Thank you, Your Honor.
Where is that one that I called?
Synchrony, is that the one?
Yeah, where'd I put that one at? Come on. Here. Where'd they put Synchrony? Okay, Synchrony Bank. Are you on this one, counsel? The other one, Mr. Royce? No. What?
Your Honor, I've tried calling again and was going through their phone system for 5 minutes again and with no answer.
I mean,
Your Honor, is Mandrich Law Group on the caption?
No, it's Rausch and
this is out
Sturm.
of Wisconsin.
It's Rausch and Sturm.
It's Rausch and Stern. I see. Look, Riki, Leonted, Eba, Sweet
When
200.
Yeah, when I call the number that's on the summons, it indicates it's the Rausch and Sturm law office.
Yeah, Rausch Stern. I see. Did you leave a message?
Judge, I can never get to a voicemail to leave a message. It would just kept transferring me from.
Recalling Synchrony Bank versus Virginia's Plemons, 2502214. Your appearance again, Mr. Filkins?
Yes, John Filkins, P70263, appearing via Zoom, along with my client, Virginia Plemons, who's remotely appearing by Zoom as well.
They failed to appear. I'll be glad to dismiss the case without prejudice if that's what you want, or I'll reschedule it. Either way, I have a feeling if I dismiss it without prejudice, they're going to file a motion to set it aside and we're going to be back to square one, but I'll do whatever you want.
Your Honor, at this time, I would ask that the matter be rescheduled, that the court consider in the future any award of attorney's fees as a result of my having to appear.
I will. Reschedule this. Attorneys failed to appear. Issue of sanctions preserved. You can bring that up on the next hearing date, Mr. Filkins.
Thank
Your
you.
Honor, we can do September 8th at 9:30.
Your Honor, I will tell the court I am leaving out of the country September 1st, returning on September 22nd. So if it's possible to have a date after.
Good enough. Give me a date after that, if you would, Jennifer.
That would be, well, we have the 22nd, so he's not going to want to be here that day. October 6th.
Wow,
Looking at,
that's a long time. Can't I do it the week of the 29th or anything?
I mean, it's probation. Do you want to throw it on at the end of
Yep.
your probation docket at
Yep.
11?
No, I want to do it at 8:30 that day.
8:30?
What
Okay.
day is that?
It's a Monday,
I know, but what date?
28th. I'm sorry.
September 28th at 8:30 we'll reschedule this for, okay?
if I could just make a suggestion here, according to my calendar, September 28th is a Sunday. I may have,
Oh, 29th. I apologize. I looked at it wrong.
all right, so September 29th at 8:30.
Yes, will be the pretrial.
Understood.
All
Thank
right.
you.
Thank you very much. Have a good day. Good luck, ma'am. Thank you.
Thank you. Bye-bye.
All right. I don't understand some of these lawyers anymore. I don't get it. Velocity versus Jessica Ochalek, 2501828.
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
I'm sorry, P49102?
Correct, Your Honor.
Okay, is Ms. Ochalek here?
Judge, she was briefly. I had placed her in a breakout room and tried to put Mr. Royce in with her, and she is gone now.
Oh, yes, Your Honor. We did speak in the breakout room, and she agreed that we should just do a 60-day discovery order. She's working with a debt settlement company. I usually tell them that we have to go back before the judge. I failed to do that this time. She may have disconnected.
Jennifer, call her up, 795-5578, 795-5578. Get her back here, please. Hamptons versus Amna Khan, Salim Khan, Santa Salim, Azra Khan, and Hyra Khan, 2502119.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Are any of the individuals here? Sir, your name, you have to unmute, get your face up nice and close to the device and tell me your name.
Hi,
Mr.
I'm Hira. I have my family here. They don't speak English. My sister and I do.
Okay, what's your name, ma'am?
It's Hira, Hira.
You are a defendant. Who's this one next to you?
It's Amna.
Amna Khan and Hyra Khan. Okay, I have you two.
And my parents are here, but they don't speak English. I have Salim Khan here, and I have Azra Khan here.
Right.
And then my sister, Sana, is also on Zoom through her phone.
Oh, boy. Okay, all right, good enough. Sana does not speak English either, correct?
They can understand, but it's not their first language, so I don't know if she would be able to explain.
What does she primarily speak?
Urdu.
Urdu, okay. Ms. Khan, I need you to unmute, or actually, yeah, Ms. Salim. Her last name is Salim, correct?
Yeah.
Okay.
First, Sana and
And can you tell me your name?
It's Sana Khan.
Well, actually, your last name is Salim, right?
Yeah, it was Salim, but after citizenship, I just changed my name. I did it Khan.
I see. Okay. All right. Now, could you have Azra and Salim Khan kind of appear in that box there and tell me their name?
Yes. So this is Azra, my mother, Azra Khan.
How you doing, ma'am?
Hi,
Can you tell me your name?
Azra Khan.
And sir, your name, please.
Yes,
Naam batana.
Salim Khan.
Good morning. How is everybody out there? Good?
Good.
Good.
All right. Now, where do I go from here except to say, did you read the response, Ms. Austin?
I did, Your Honor. I did, Your Honor. And I know it's not a formal answer, but I would have to accept it as an answer. I'm not going to file a motion for a more definite statement, but if we could get maybe 60 days of discovery, maybe we can get this resolved. So they moved out before the end of their lease term, and that's the gist of the complaint is that, they owe the 2 months for.
Right. Okay. I want to try to explain something to you, Hira and Amna. And I want to make sure that I'm doing a good enough job here to explain it to Sana and your parents.
Okay.
If I need to have you have to interpret, you tell me.
Okay.
Now, it appears as though your answer, your letter, acknowledges the debt. In other words, you seem to be saying in here, we cannot afford the 2629 being requested. Now, if that's the case, there's no reason for me to set this for trial. If you agree that you owe the debt, what could happen here is I can put you in a breakout room with Ms. Austin. Maybe, I'm not trying to put words in your mouth, but maybe you agree to a judgment and we set up a payment plan that everybody can live with. Nobody wants you or your family not being able to eat or pay rent or pay the essentials of life, okay? So a lot of this depends on who's working, how much they're making, where you're living now, what kind of bills you have. Do you have a car payment, a cell phone payment, a house payment, a rent payment? Those kinds of things. Am I making sense?
Yes. I just want to understand one thing. We thought that the security deposit and the last month rent that we left would cover the whatever the remaining thing was when we were leaving. So did that not count towards the remaining balance?
Did you apply the security deposit to your client?
There's a security deposit of $680 that was applied.
Were there any damages?
It looks like they had to replace it for $444 due to red, dark.
Or what?
And again, maybe Your Honor, maybe a 30-day adjournment, and I must Hira Khan's email address while we were in a breakout room before we came to see you.
All right, look.
Send her what I have. We can try to work out a payment arrangement, come back in 30 days, see you, and hopefully.
I have no problem with that. I'm gonna adjourn this pre-trial. Jennifer, give me a date, but I wanna make sure I'm explaining things appropriately for you two, okay? She's saying they applied the security deposit, but there's some kind of $444 charge. Can you tell me what that was for?
It looks like some carpet was replaced, Your Honor. I have some photographs that I'll send her as well.
Okay, how old was the carpet though? I mean.
I don't know how old the carpet was, Your Honor.
Well, I know, but here's the thing. They don't get to go buy new carpet and then stick the tenants with the whole charge either, right? It's depreciated.
You of the old carpet. I appreciate that.
Thank you. But they don't like to do that. They gotta have guys like me ask questions and make sure it's done right. But I'm just gonna leave you with that thought. Here's what I want to tell you two ladies. This is a courthouse, a courtroom. If we hired a painter and this carpet was 25 years old and they didn't put down drop cloths and we had to replace it, we'd only get the value of what the carpeting's worth now before the damage, as opposed to coming in and buying all new carpeting. Okay? So I'm going to ask you to negotiate with them with that in mind. If I need to hire an interpreter at any time, bring in an interpreter for Urdu, I will do that. Right now, I'm going to adjourn this for 4 weeks.
Okay.
Give me a date mid-September, Jen.
September 22nd at 9:30.
Okay? So I'm going to make a note here. Sana Salim is now Sana Khan.
Yes, correct.
Amna and Hira speak English fluently. Is that true, ma'am? You think you speak that fluently?
Yeah.
Yes.
And I want you to correct me if I'm wrong on this. Salim Khan and Ezra speak some English,
They
but not fluent. Is that true or false?
they can just like greet and
I see.
yeah.
So we'll need interpreter on that.
Mhm.
For that, but I'm not going to bring them to the pretrial because then I got to charge interpreter fees and they're really expensive now. I don't know why.
If it's okay, we can translate to them.
I understand. So let's do that for the pretrial. You talk, translate with your parents, get Santa involved. I'm going to adjourn this to September 22nd at 9:30. And I'm going to hope that you guys can resolve this. Okay. I will not conduct the pretrial now.
Okay, thank you.
Okay, am I being clear at all, or do you understand what I'm trying to say here?
Yes.
How about you, Anna?
Yeah.
Okay, all right, good luck. We'll see you September 22nd, everybody. Thank you.
Thank you.
Thank you.
All right. Velocity versus Ochalek. 250-12828. Your name, ma'am?
Jessica Ochalek.
Mr. Royce, your appearance?
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
Okay. Now.
Yeah.
All right. You don't think this is your debt, Ms. Ochalek?
No, it is.
Do you dispute any of the figures?
No.
Why are we even conducting discovery? Because of the debt settlement? I mean, you know.
Sorry.
Go ahead. It's all right. But I'm not prepared to just have debt settlement companies hold up cases here. I mean, they're either going to come into the foray and get involved, or I'm not going to just keep putting things off and setting discovery. If you agree that, the debt, then maybe you can go in with Mr. Royce and resolve this.
Yeah, I thought I had payments set up since 6/13/25. So I wasn't sure why this even went to court.
Mr. Royce, have they been paying on the debt?
No, Your Honor. My understanding of debt settlement companies, they have them start paying, and once they get a pot of sufficient funds, then they contact to settle.
Well, that's nice.
There has been they have contacted us, but they have not even made an offer yet at this point.
No, of course not. They delay. I'm not prepared to delay. So I'm just going to set the thing for trial. That's what I'm going to do. You can have discovery if you guys want until September 26th. We're going to set a trial date in October. Witness lists are due on September 1st. We're going to set it the same, 1/2 hour again, Jen. I'll give you no jury trial demand, no nothing, no settlement conference. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. And that's it. So give me a trial date in mid-October. And I'll do that for you guys. I'll give you 35 days or whatever. Maybe you can get the debt settlement company moving, but I'm not going to hold my breath. Give me a date in mid-October, Jen.
October 20th at 10:30.
At 10:30, all motions for summary have to be filed and heard not later than 20 days before the trial date. She's admitting the debt. If you file your motion, I can't imagine me not granting it, if you, assuming the appropriate documentation is in line. Okay, thank you both.
Thank
You're all
you, Your
set.
Honor.
Have a good day. Good luck, ma'am.
You too. Thank you.
All right, now what do I have up there? Do I have this towering construction? What time's that on? And SND Investors?
Judge, I have University of Michigan that are in a breakout room.
You have the files?
And SND Investors, the plaintiff is here. I have an iPhone that just logged in, so it could be the defendant on SND.
You have that, Tabitha?
On the iPhone, can I get your name, please?
The iPhone, you need to unmute and put your name on there so we have a clue who you are, okay? Unmute. Faizan Zulfikar Chowdhury.
Right to the podium.
25B148-998. Your name, sir?
Faizan Zulfikar Chowdhury.
Officer, your name?
Officer Cobbs, sir.
Good morning to both of you. Could you two talk? Do you want to try to resolve this?
Yes, sir. We come to understanding. I'd like to move to dismiss the ticket if you're okay with that.
If that's what you're comfortable with, it's just a prohibited parking. You're not gonna park there again, though, right?
We work that out, yes. No, we understand.
All right, case dismissed, motion to plaintiff. You're all set.
Thank you, sir.
Have a good day. Thank you. Good luck to you both. All right, who else do I have here? Sir, what is your name? You have to tell us your name.
Ladero Kurt Gardner.
Okay, S&D, let's do that one. Is anybody here? I thought they were here. Am I right or wrong? I thought you said somebody was there from S&D. Do I have anybody here on University of Michigan Credit Union versus Villarini? Jen, are you out there?
Judge, did you need something?
No, I'm good.
Okay, I'm sorry.
No, you're fine. You're fine. I just wondered, Jen had told me SND Investors was out there. Mr. Gardner is here. Garner. And I don't know what happened to SND Investors. And I don't know if we have University of Michigan Credit Union. It should be a lawyer, Scott Chernich out of Lansing. And
They are in a breakout room. The U of M Credit Union, they're in a breakout room still.
Where's S&D Investors lawyer? Should be either Daniel Goldman or Scott Mancinelli.
I will bring him in right now.
Okay, thank you. Mr. Goldman, you can start your video. This is S&D Investors LLC versus Ladero Garner. Your appearance, counsel?
Judge, I can't hear you.
You can't hear me?
1 second, please. What's going on?
I can hear you.
Forgive me, Your Honor. I want to test my. Honor, can you hear me now?
I can hear you. Can you hear me?
Yes, Your Honor. It's a little, yes, forgive me. I can.
Okay. Your appearance?
Your Honor, Daniel Goldman, 64231 for the plaintiff S&D Investors.
Mr. Garner, your name?
Ladero Gardner.
I read their answer, their motion, Mr. Garner. I'm inclined to grant their motion for a more definite statement, at least. More motion, so that would mean that you have to either admit or deny each allegation in the complaint.
Okay.
Or neither admit nor deny for lack of sufficient information. You can also assert affirmative defenses, but you can't just, you're almost admitting the debt here. I'm not in dispute of the debt ownership of the account, but if you're unable to provide the full report of how you validated, verified, and how you were in compliance, you must remove the account from my credit report. That's not appropriate for an answer. So here's what do you understand what I'm trying to tell you here?
Yes.
Mr. Goldman, I'm simply prepared to require the defendant to file an amended answer within 21 days.
Your Honor, I understand. Forgive me.
Go ahead.
Your Honor, we were here on July 15, and Your Honor, at that time, indicated that you would order him to file an amended answer with 21 days. No order was entered. We did file, Your Honor, a proposed order under the 7-day rule. I don't see that that was ever entered. But that answer should.
I didn't realize that. My apologies here. Okay, C order I signed. Reschedule court date. Notify plaintiff attorney I will not be signing an order to the above effect. What is going on here? Hang on 1 second. Wait 1 second. Jennifer, you need to enlighten me here. What is going on?
I'm sorry, Judge. It's Linda.
Where's Jennifer?
She's dealing with Amanda Mount.
Well, Amanda Mount's going to have to wait. I mean, I don't have to tell her.
All right. I will get her right now.
Please.
Your Honor, if you would indulge me, I could tell you what I recall. I have notes.
Go ahead.
Thank you, Your Honor. So we were here on July 15. The defendant failed to appear. We asked for default. Your Honor took some time, thought about it, and then said, I can't give default judgment, but what I will do is enter an order requiring the defendant to file.
Hi, Judge. Sorry.
It's okay. I need you on this one. This is Garner, SND Investors LLC versus Garner. It looks like go ahead, counsel. I'm going to let him explain. They were here previously. The defendant didn't show up. This is on the plaintiff's motion to strike the answer.
Your Honor, and so we requested default. Your Honor, was going to grant that, then hesitated, then said no. Then Your Honor indicated.
Mr. Garner, hang on a second. Okay, you were in the hospital. I get it, but let him finish, and then I'll address all this. Go ahead.
Thank you, Your Honor. And then Your Honor indicated, but I will require the defendant to file an amended answer within 21 days. You said if the defendant fails to file an amended answer, then we can file our motion again. And those notes I entered at 10:57 a.m. right after the hearing.
Okay, so Jennifer, here's my notes on, that was July 15th. You were in the hospital July 15th, Mr. Garner?
Yes.
Okay, this is what I wrote on July 17th. I said, C order I signed, reschedule court date. Notify plaintiff attorney I will not be signing an order to the above effect. Motion will be addressed on August 12th at hearing. Why did I write that? Did we get some kind of note that he was hospitalized?
Judge, we got a motion from the defendant that they had a procedure and were going to be in the hospital.
Okay, all right.
And that crossed paths with the court date because of M file. It was in a box waiting for signature.
So that's
all that
what
stuff.
happened. When I had the when you appeared July 15th,
right.
He was hang on, Mr. Garner. He was in the hospital. So I'm not going to enter an order on somebody without them being present, particularly if they're in the hospital. Okay. So that's when I said I'll address all this today. So that's where we are. I'm going to,
Your Honor, your legal assistant indicated a motion was filed. I have no evidence of a motion being filed by the defendant.
No, your motion. Your motion was.
No, Your Honor.
There was a motion by the defendant to adjourn that was filed, and I can look at the service notice. Give me 1 second. It was filed on July 3rd.
We don't have it. I don't dispute it. We just don't have it.
I understand. Listen, this I'm filing.
Yeah, it was. It was downloaded on 8/4. It looks like downloaded on 7/16. Downloaded on 7/14. So it looks like a couple different people at Mandridge Log downloaded it.
All right. So what I'm trying to tell you here, Mr. Goldman.
Yes, sir. That's fine.
Is I think my intent from what I'm reading in my notes now is that I'm simply going to go back and address your motion to strike your answer and enter default, or for a more definite statement. And so I think I was right with what I said in the beginning, but I didn't know all these other events had transpired. So, sir, Mr. Garner, I want you to understand something. I'm going to order that you file an amended answer to complaint
Oh, hey,
within 21 days. You have to, and I know you're not a lawyer, but you either have to admit each allegation, deny each allegation, or any combination thereof, or indicate that you do not have sufficient information to form a knowledge about whether the allegation is true or false, or whether or not it's to be admitted or denied. Do you understand that? If they
yes,
alleged that you were in Tahiti one day, or somebody was in Tahiti and you don't know, you would say neither admitted nor denied for lack of sufficient information to form a belief about this truth or this averment. So you either have to admit, deny, or neither admit nor deny based on that ladder that I just went through. And you have to do that within 21 days.
okay.
And then after you do that, did I ever conduct a pretrial on this?
I don't believe
No.
so.
No, Your Honor, I don't believe it ever had a pretrial.
This case been going on since April. So here's what I'm doing. Counsel, submit that order. You have to file an amended answer to complaint within 21 days. And I'm going to set this for a pretrial. So let me just make some notes here. Defendant to file amended answer to complaint within 21 days. Now, sir, if you don't do that, I'm going to give them a default. So I understand you're not a lawyer, but you have to be able to follow the rules here. I can't do it for you. We're going to also set pretrial for September what, Jen? Middle of September. Are you there?
Yes, Judge.
I understand. So about 4 weeks out.
Yeah, I'm just looking to see what we got here. Oh, the 8th. It would be September 8th.
Well, I want to get his answer before then. I want to have his answer. What about the 15th?
Okay. Well, that's probation, but if you want to add it in the morning, or we can do the 22nd.
September 15th at 8:30, okay? That will be another day that you have to return, but you have to file your answer, sir, amended answer to complaint within 21 days. You'll prepare the order, Mr. Goldman?
I will, Your Honor.
Sorry for the confusion, everybody.
I wasn't trying to argue with you. Forgive me. I understood your ruling. I just wanted to clarify it.
No, you weren't. I didn't take you as arguing. Listen, this I'm filing, we've been doing for 2.5 years probably now, and it's no fun. I mean, it's easier for everybody else but courts. And I get it, but I only have half of a file here typically. I have some notes. The staff does a great job, but I just do what they tell me to do up in Lansing, Mr. Goldman. That's all we
I'll
try.
do what you tell me, Your Honor. I'll have an order under the 7-day rule.
Have a great day. Actually, you don't even have to submit it under the 7-day rule. Just submit an order today and I'll sign it. Mr. Garner, do you understand everything here?
Yes.
Good luck to you, sir.
Your Honor,
I
do you have
hope
an
you're-
email? Is there an email address we could send this order to?
Jen?
File it, please.
Very well.
Okay, thanks.
Thank you.
November Credit Union versus Michael Villarini, 2501493. Good morning, Mr. Quinn, your appearance?
Morning, Your Honor. Patrick Quinn on behalf of University of Michigan Credit Union.
Mr. Villarini, your name?
Michael Anthony Villarini.
All right, so you're suing for 6712, right, Mr. Quinn?
Yes, Your Honor. And actually, in our last breakout room, I think me and Mr. Villarini were able to come to a payment plan agreement. If we could maybe run that through the court and see if the court's agreeable.
Consent judgment?
Yep.
Good, fine. Go ahead and provide me with the terms.
Yeah, so I think we would start at $100 a month. And essentially, just for some background, Mr. Villarini is currently out of work and he's expecting a settlement from a workers' compensation injury. So I was thinking at 12 months into the payment plan, we review his ability to pay. If nothing changes, we continue on with $100 a month until the balance is paid off.
So give me the total figures here. What do you have,
It
including
should be
costs?
$6,712, Your Honor.
Are you not asking for any other filing or service or statutory attorney fees?
No, Your Honor.
So the total settlement, the consent judgment will indicate 6712. Defendant to pay $100 per month beginning when? September 1?
Sure, Your Honor. I think that's, as long as Mr. Villarini's okay with that.
Can you do that, sir?
Yes, I'll make it work.
I'm sorry?
I'll make it work.
And then, so you're also asking for a review hearing on the payment plan after 1 year?
Yes, Your Honor.
All right, this is what we'll do then, Mr. Villarini, and I want to make sure you're okay with this, Mr. Quinn. This would be a consent judgment in favor of the plaintiff and against you in the amount of $6712. You would have to pay $100 per month beginning September 1. The other orders portion of the judgment will indicate this payment order is subject to review on motion of either party on or after September 1 of 26. Is that acceptable, Mr. Quinn?
Yes, Your Honor.
Is that acceptable to you, Mr. Villarini?
Yes, Your Honor.
Does Mr. Quinn have your permission to sign your name to the proposed consent judgment outlining those terms?
Yes, sir.
Do you have any questions for me at all?
No, Your Honor. I just want this to be over with. Thank you.
I understand. I wish you a good recovery with whatever it is, and I hope everything works out for you. Best of luck to you.
Thank you, Your Honor. Have a good morning.
Thank you. Thanks, Mr. Quinn. Have a good day, gentlemen. Thank you. All right. What else do I have down there? Do I have Rosalino Gaglio?
He's in the courtroom. Right.
Do I have Angelina Jade Vila? Rosalino Gaglio versus Angelina Vela, 2502794. Good morning to you. Your name? I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. So the defendant did not show up. I just want to ask you a couple of questions here. Did you, so you're saying the accident was her fault?
Yes.
Was she ticketed?
Yes, she was.
All right. Did you get your car repaired?
No, it was totaled up.
Do you have proof of that?
Yes, through my insurance company.
How much of so when they totaled it up, how much did they pay you?
They gave me $4,008.
Did they take off a deductible of $1,000?
Yes, they did.
So that's what you're out of pocket.
Yes.
And you're under oath. You understand that, right?
Yes.
Well, that makes this easy. I can always use an easy one, Mr. Gaglio. So I'm going to give you $1,000 plus you get your filing fee of 68. Did you have a service or process fee or did they sign?
What?
Wait a minute, Jen. Was this doesn't even look like it was signed by the recipient.
Judge, yeah, I know. They just drew lines. That was the signature. I mean, that's what.
What do you mean? Who drew lines?
Well, whomever signed for it. You have I know, that's all they did at the post office, required it.
How am I supposed to give this gentleman a judgment when we don't have a signature card? Jeez.
You have the one that they submitted back to us, correct? That's what the post office sent back to us saying that it was signed for.
Well, what does that mean? Joseph could sign for this thing. I mean, anybody could sign for this thing.
I know. Yeah, they just drew 2 lines across the recipient name and
Jeez.
And say that it was signed at that address.
Sir, I am really sorry. I cannot give you a judgment without proper service. There's not proper service. The defendant has to be served personally here. If this was a corporation, essentially on small claims, anybody could sign for it at the corporation. but there's not proper service, I will adjourn this and you're gonna have to probably get a process server to go out and find the person.
I'm the lady that hit, the lady who got ticketed is what you're saying, Ross?
The defendant, whoever struck your car,
Okay,
Ms. Vila, it looks like.
I had to go find them.
I can't enter judgments.
Talking, I don't know.
I cannot enter judgments against people that weren't properly served. I have rules I have to abide
No, I
by.
understand that. I figured it was a long shot at judge because they went to get a Minotaur and the information she gave the officers is not true. She has no policy with Progressive that she claimed she had. So she basically fraudulently told them and.
Yeah, I know.
I get the.
There's all kinds of people running around doing that kind of.
Well, yeah,
nonsense.
understandable. But I tried.
Well, you still can try to pursue this. You could get a process server and have him go out and find her. You know, presumably she's at this address. They can run postal inquiries. They can determine whether or not she's still there.
Do they charge for that? I mean,
Yeah, I mean.
Is it a significant amount or I don't know. I've never.
I mean, it depends how easy it turns out for them to find the person.
The person?
You probably, in a case like this, they live in Detroit, it depends, but you can count on paying, what would you say, Jen, between $68 and $120, depending on how much time, but I can't speak for process servers. They're independent contractors.
I get you.
I'll reschedule this and she'll explain everything. But there's just not proper service here. I'm sorry, I really am.
So if you will adjourn, if I have to take another day off, can I add to that because of all this?
I can't give you wage loss.
Okay.
Where do you work?
I work for GP Cement Company.
I know, well.
And I took the day off today, hoping.
I understand.
I get your position, Judge, so.
Jennifer, I'm gonna indicate you can Zoom. Do you know how to Zoom?
I don't really.
Get somebody to teach you. It's easy.
I got sisters.
A dummy like me, technology wise, can do that. You got,
Yeah, I get it.
okay? So, yeah, you can do that if you want, all right?
Okay, do I speak to somebody else?
You'll go talk to the civil department.
Okay,
I wish you well.
thank you.
Sorry I couldn't accommodate you here.
Judge.
Good luck, thanks.
Thank you.
What else do I have here? Good morning, Mr. Carmen. How are you?
How are you, sir?
Good, thanks.
Good.
Brown? Oh, wait a minute. I mean, Natalie Nicole Brown, 25F25894442, your name?
Good morning, Your Honor. Michael A. Carmen, P7384, on behalf of the defendant.
Why weren't you here?
I thought my court date was scheduled for the 8th, and I called that morning to find out that I had missed my court date. And also, my daughter was sick with hand, foot, and mouth the date I actually had my.
Okay,
court
listen,
date.
I cannot sentence you now. I'm not gonna do this. I read these reports. And I'm just sorry, we're gonna have to reschedule it. I'll do that for you, but I just don't. I mean, I knew it was only 10 days ago or what have you, but I still want to go back and look at this file. Jennifer,
And Your Honor, if I may also, it was incumbent upon her attorney to remind her of her court date, and I failed to do so, so definitely on me.
why? What do you mean? You guys got to remind everybody? What's going on in this society? I got lawyers not showing up. Now you're telling me you got a reminder? We gave her a written notice, right?
I'm not sure she went down and got it, Your Honor, so I should have better.
I'll reschedule to September 4th at 8:30. You can go down the hall and get your notice, ma'am, okay? Good luck. Thank you. You got to show up on time. I'm going to expect you here at 8:30 that morning, all right? Thank you, Mr. Carmen. And by the way, I'll reinstate her bonds. Bond reinstated, okay?
Very good, Your Honor.
With
Thank you so
the
much.
same terms and conditions. Good luck, ma'am.
Thank you.
All right, do I have anybody, where's this towering construction file? Do I have that? You have that down there?
I don't have anything.
I think those are time clocks.
Do we have any other file that I can call?
Judge, everything I have is for 10 and I don't have everybody checked in yet.
All right, well, I'm gonna get off the bench here for a couple of minutes and see what's gonna happen. Stay seated, sir. What's your name?
Robert Burton, sir.
What time are you up?
10 o'clock.
Okay.
I can bring them in.
Okay. On record.
Yes, John.
CKS Prime Investments LLC versus Afi Cobbs. 2502297. Good morning, gentlemen. Your name again?
Good morning.
Oh, go ahead.
Hey, Cobbs.
Good morning.
And Chris Royce, P49102 on behalf of plaintiff.
Is there any kind of resolution on this, Mr. Royce?
No, Your Honor, Mr. Cobbs and I spoke prior to the hearing, and I think we're gonna be able to get it resolved. I've gotten his email, I sent my contact information, and I think that we will probably have this resolved within 30 days.
We'll adjourn the pretrial for 4 weeks with the hopes that you two will resolve this, okay? Give me a date, Jen, the other one you gave me.
The 22nd at 8:30?
No, didn't I do another one earlier?
Oh, the
4 weeks?
15th at 8:30?
I thought there was an earlier one.
Or you have the 8th.
Yeah, let's do the
That's a
8th.
little less than 4 weeks, but yeah.
So,
Okay, the
8:30.
8th at 8:30.
Yep. Okay, you guys, we'll adjourn the pretrial to September 8th at 8:30 with the hopes that you'll resolve it. If not, I'll just set a short discovery period and set it for trial, okay?
Thank you, Your Honor.
Have a
Okay.
good day, gentlemen. Thank you.
Yep.
Judge LV, NV, and Burton are ready?
Okay. Wait 1 second, sir. Sir, just wait 1 second till I call it, okay?
Push that one, LBNG.
Just give me all of them.
Yeah.
LVNV versus Robert Burton, 2501460.
Good morning, Your Honor. Elizabeth Rameri, P66, standing in for attorney of record on behalf of plaintiff LVNV.
Your name?
Robert Burton.
Did you file bankruptcy?
Yes, sir.
Do you have proof of that?
I have everything right here. I'm just waiting for everything to get finalized. I got certificates and everything, sir.
Did you give that to the civil department?
No, I have not yet.
Did you send it to the plaintiff's counsel?
No, I have not yet.
But your lawyer filed your bankruptcy.
Yes, sir. I'm filing it. I'm just going over everything right now.
Wait a minute, slow down.
That's
Slow
all
down.
I have.
Has it physically been?
No, it has not.
Okay, I mean, I don't, I'm gonna adjourn it one last time for 2 weeks. If you haven't filed bankruptcy, I'm gonna set it for trial, okay? August 26th, Jennifer, at what time? 8:30. We're gonna adjourn the
Judge, yes, I'm sorry. Yes, that's correct.
August 26th at 8:30, okay?
Very well, thank you, Your Honor.
Think you'll have it filed then, right?
It should, yes, sir.
Okay, because I thought last time we were gonna have it filed by today.
Yes, I had all the paperwork.
All right, just make sure you get it filed. If you don't, then we'll just set it for trial, okay? Have a good day. Thank you. Thanks, counsel. April Langston versus Elena Concrete Services, 2501181R.
Judge, I've not had either party appear on this, and this was the one that we had a motion to consolidate on. And at the time, we gave them a new notice for the pretrial and neither party has appeared. I can call plaintiff or defendant's attorney.
Give me the rest of those. Yeah, do that, okay?
Okay.
TD Bank versus Kristen Gazdecki, 2502123.
Judge, they're still in a breakout room. I can get them to move out.
Give me the Bynum, Towering Construction versus Bynum.
Judge, I don't have that on the docket. Was that a motion? We got two that came off right at the end of the day yesterday.
I don't know. It's 2501334.
Oh, there was a stip and order to adjourn that just got filed with us. We've moved it to September 8th.
Tabitha, hold on. It's September 5th.
Yes, Judge.
Why? What did they need an adjournment of this for? Did
I
they say-
didn't look at the poll. I'd have to pull up the stip.
So simple motion to set aside the falls. I don't know what to do. I'll let you call them. TD Bank versus Kristen Gazdecki, 2502123. Your name, ma'am?
Kristen Gazdecki.
Counsel?
Good morning, Your Honor. Seth Goldner on behalf of the Buckles office. I'm of counsel representing the plaintiff today. Good to see you.
Good morning. You too. Is there any resolution on this?
Well, Your Honor, we were we had a wonderful conversation from my point of view, a lot of information exchanged. I felt like we made a lot of good progress, and I was about to get to the part of the conversation where I tried to see if we could resolve. So let me just ask Ms. Gazdecki directly. Ms. Gazdecki, we did talk about potentially having you stipulate to a judgment and then work with the Buckles office on a payment plan afterwards, or another option that the court, Your Honor, I believe plaintiffs filed a motion for summary disposition. So I think we have two options.
Why don't I put you guys back in the breakout room? I dragged you out of there, I think. If you guys need to finish your conversation, I don't have a problem with that.
I'm fine with it. Kristen, do you want to talk for another minute?
No, there's nothing else to talk about.
Okay.
So ma'am, you don't stipulate, you don't wish to proceed with a judgment at this time and a payment plan?
Judge, if I can say something, I had filed a hardship with their office. They sent me a hardship form because I filed for disability. I have over 200 and I don't know, 20 or 30 days left for determination. So I offered a payment plan and it was denied. They said they want either $4,900 up front for a one time, or they wanted $500 or $600 a month for 2 years. That was from the previous attorney that represented this case 2 weeks ago that spoke to you. And she said they will not take less. I called the office yesterday. I offered $50 a month. They said, no way. So
Slow down. So there's two aspects to every lawsuit. One is, for lack of a better term, is the defendant liable for the amount of money claimed? And two is, at what rate are the payments going to be made? If there's no dispute as to the fact that you owe the amount set forth in their complaint, which is $6,026.31 plus their costs, you can stipulate to a judgment and I can determine what the amount of the payments will be. I'll ask you questions. I'll swear you to an oath. Mr. Goldberg can ask you questions and we can present a consent judgment for $6,026.31 plus any costs. And I can make the determination as to how much you can afford to pay. Does that seem reasonable?
yes.
So does Mr. Goldberg, how much do you have in costs? Do you want your costs?
Yes, Your Honor. And if I may, just to give you a little background, what I was discovering when I talked to the defendant was that she had, the Buckles office has a financial hardship review procedure, and she had just started the process of providing information. So normally we would hope to have that conversation earlier before the hearing, but the timeline didn't provide it. So she is in the process of verifying her hardship. I have no authority to accept any particular amount of a payment plan, but my practical suggestion would be as follows. One would be based on the answer that we do enter the judgment, either by stipulation or perhaps, pursuant to our motion next month, but that in the meantime, now that we're aware of the hardship and Ms. Gzdecki has started to provide some information, perhaps we can take her hardship into account ourselves and not have to take up the court's time with a motion for installment payments unless it's necessary. But Your Honor, I want to do what's efficient. I want to do what's right. I don't want to push Ms. Gzdecki at all. She is starting to do the procedures that the Buckles has. She's been a little frustrated by what's happened so far, meaning she just hasn't been able to get any concurrence to the kind of plan she's proposing. I don't know that it's unreasonable, but we have a procedure and due diligence we have to follow. So we could either, my thought would be enter the judgment today and work with Ms. Gzdecki and hope to come up with a payment plan, or kick the can until the defendant's motion and work with her in the meantime, or.
Working now, ma'am.
No.
How are you supporting yourself?
What I'm doing is my son has 2 toddlers and another one on the way, and I help his wife because she's a stay-at-home mom. So he doesn't directly pay me. He'll pay like my, phone bill, and he gave me a car to drive, pays the insurance. He gives me money for gas. I do live in Section 8 housing, so I do not have a rent payment, only $5. I do pay electric, which it's minimal. Those are and internet is $14 a month, and I receive food benefits.
Okay, so I don't care how we do it. It seems like it's in order for a judgment to be entered today. If you want me to decide on the installment payment order today, I'll do that. And I'll enter a separate order. If you want to deal with them on the hardship, that's fine. Whatever you want. But it doesn't make any sense to prolong the case if you owe the debt, is what I'm trying to tell you.
Yes, and that's what I agree. Why would we prolong it? Because I already agreed I owed it, and I asked for like a hardship payment plan, and they won't give it to me. So yes, if you could give me something that I could easily afford, I would love that because I want to make payments.
Any problem with that, Ms. Buckles?
Oh,
I mean, I'm sorry, Mr. Goldner.
Yeah, no, it's all right, Your Honor. Well, Your Honor, the Buckles office, as you know, is very well run, very procedurally oriented. I don't have the authority to say yes or no. I'm not going to, I would just ask the court to let us work out our own hardship procedure because but whatever the court wants.
This is what I'm going to do. What kind of costs do you have? Let's start with that.
Your Honor, I think it's about 137. Give me a moment and I'll recite the exact.
So they are entitled to those, ma'am. You owe
Okay.
$6,026.31.
Okay.
You also
I'm sorry to interrupt. 135.20 in court costs, and the particulars are 135.20. The particulars are $75 filing fee, $40.20 service fee, and a $20 motion fee.
So that's 6161.51, right?
That's exactly right. And then interest.
Now, let's do this. Does he have your permission to sign your name to a proposed consent judgment indicating that you owe them $6,161.51? Let's start with.
Yes, sir.
So you're going to prepare that judgment and send it over, and she's just giving you permission to sign her name. Now, I suppose technically I should make you file a motion, but I'm going to waive your fees anyway based on what you've said. And there's no hardship or prejudice to them. So I'm going to swear you to an oath, and I'm going to determine in a separate order how much you're going to pay on that. Okay? So I'll ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
All right. All right. What sources of income do you have?
I have zero. The only income that I have, like I said, well, from that it's a donation, but I sell clothes on like my stuff online just to make a little bit of money.
And how much are you asking to pay?
I was asking like 50 a month. I mean, I could possibly do 75, but that would be the absolute max at
Have
this
you applied for
time.
disability, ma'am?
Yes, I did.
Where is that pending? In other words, what stage is that is? Did you just apply? Did you apply 7 months ago, a year ago?
I applied in February. You have the file. I turned it into the court last week. It was a
I believe
copy.
I believe you.
It was in February.
Slow down a second. Mr. Goldner, ask any questions of her that you would like.
Oh, well, Ms. Gazdecki, is all the information that you shared with me in the breakout room accurate?
Yes.
All right. Well, I'm satisfied, Your Honor. The only stipulation or the only condition that I would suggest, if the court would be willing, in whatever amount that the court wants to set for this payment plan's fine, we would just ask for a 6-month review opportunity.
Fair enough. Here's what I'm doing. I'm gonna make it easy. I'm gonna ask you to prepare an installment payment order that I've set up, not make clear that you're not consenting so you don't get in trouble. You're gonna do a separate judgment in the amount of 616151, then an order for installment payments that calls for her to pay $50 per month beginning September the 1st of 25. And then this order is subject to review on motion of either party on or after March 1st. Okay?
Okay.
Will you send that over to me too, Mr. Goldner?
I will, Your Honor, I will. I'm not the drafter, but I'm going to immediately report to the Buckles office. I'll immediately let my supervisors and the attorneys who would generate that know. And with a little luck, we'll get that e-file today.
Perfect. Thank you. Have a good day, Mr. Goldner. Ms. Gazdecki, do you have any more questions?
Do I come into the court to pay or can I pay online?
You're going to pay their office direct.
Oh, okay.
Do you want to tell them how to do that?
Oh, yeah, we'll put the instructions in the order.
Okay.
And then will I receive that in the mail?
Yes.
Okay. Okay. Sounds good. Thank you so much, both of you. Thank you.
Good luck, man. Wish you well.
Okay. Thank you.
Very welcome. Your Honor,
Okay.
thank you for giving us the time today. I do appreciate it.
No problem. Have a great day. Thank you.
Thank you, both of you.
All right, take care. Bye-bye.
Thank you.
Bye. All right. JP Morgan versus Colin Snyder. 25-02676. Good morning.
Good morning, Your Honor. Elizabeth Riveri, standing in for attorney of record on behalf of plaintiff JP Morgan Chase.
Give me 1 second, please.
Of course.
What is your P number?
66192.
All right. Good morning, Ms. Law. Your appearance?
7, appearing on behalf of the
Wait a
defendant.
minute. I only caught the last couple words there.
Good morning, Attorney Brittany Law, P83917, appearing on behalf of the defendant.
All right. No resolution here, I presume.
Not as of yet, Your Honor. The parties did have an opportunity to speak. It's my understanding that the defendant continues to work with the debt consolidation company. Ms. Law has indicated that the company has reached out to plaintiff's firm with an offer. I don't have any notes or indication that an offer was made, so I've asked her to reach back out either to her client or the debt consolidation company to have them contact the plaintiff's firm with that offer so that we can continue discussions.
Okay. Witness list due September 15th. Discovery cutoff October 15th. You don't have to file a trial brief. If you choose to file, it has to be filed and exchanged not later than 7 days before the trial. No settlement conference, no ADR. All motions have to be filed and heard not later than 20 days before the trial date. Jennifer, give me a trial date in early November, mid-November. Same time as I said any of those other ones, if you would.
November 17th at 10:30.
November 17th at 10:30 will be the trial date, okay?
Very well. Thank you, Your Honor.
Anything else? Have a good
No.
day, you guys. Thank you.
you.
Okay, so this one has to be worked on. Did he come in to do his signing on record?
He has not been contacted me, Your Honor. I called him and said,
Well, can you come over to Grosse Ile and see what's going on? Do we have the parties showing up on Langston versus Elena Concrete?
Judge, no, I spoke with Ms. Elena Concrete's attorney, and she did not have today on her books. I know we gave the notice to the plaintiffs when they were here. She was asking if we can adjourn it to the 26th at 10, just.
I'm gonna let you reschedule it, okay?
Okay.
Send it to both parties. Thank you. Do I have anything else this morning?
They do have an 11 o'clock arraignment with Mr. Bogart on your docket.
Did we set that or how'd that get set?
Judge, I'm not sure. I know Lisa's on a training Zoom this morning, so.
She's what?
She's on a Zoom training this morning.
So I've done everything on my civil docket then, right?
Yes. Yep. Civil is done.
Judge, they have no detectives available for a Senate. We don't have nothing to tell about.
B 714630. Mr. Bogart, your appearance?
Good morning, Your Honor. David Bogart appearing on behalf of Mr. Sertaj, who is present, seated to my right in the office. He appears via Zoom. He consents to appearing via Zoom and waives his physical appearance. Mr. Sertaj, please tell the court your full name.
David Ronald Sertaj.
Sergeant, your name?
Detective Sergeant Morrison, Brownstown Police.
All right, so this is home invasion in the first degree. Does he stand mute, waive formal reading?
That's correct, Your Honor. Thank you.
I will enter a not guilty plea for him. Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. If you cannot, and also if you choose to submit the questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. Probable cause conference will take place. In this case, you'll be in front of Judge Hessen on August the 26th at 9 in the morning. Preliminary exam, September 2nd at 11. At the preliminary exam, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, they'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes.
All right. So I'm going to listen to anything you have to say regarding bond. Sergeant, he has not been printed as of yet. Is that true?
That's true, Your Honor.
All right, go ahead, Mr. Bogart.
Thank you, Your Honor. And Your Honor, first thing I'd like to address is I understand the PCC is on the 26th. Is there any way the court can make that on the 2nd of September as I'm on a vacation and Mr. Sertaj would waive the 14-day on that if that meets with the court's approval?
Yeah, Judge Hessen's going to try to get her state done though. So I'm going to give you September 2nd and September 9th. So let me take that waiver. Sir, your lawyer's asking for an adjournment. You have the right to a probable cause conference, as I said, within 14 days. He's going to be out of town that week. He's asking for me to adjourn the probable cause conference to the 2nd of September. If I do that, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes.
You waive that right?
Yes.
Anybody forced you to give up that right?
No.
All right, I'm going to accept the waiver. I find the waiver's been made voluntarily and understandingly.
And then I'll address bond, Your Honor, at your convenience.
Hang on one second. So 14-day rule waived. So the probable cause conference will now be September 2nd at 9, preliminary exam September 9 at 11. September 9 at 11. I'll listen to whatever you have to say, Mr. Bogart.
Thank you very much, Your Honor. Mr. Sertich is, he's working full-time. He's a lifelong Downriver resident. Your Honor, this case is not what it seems on its face. There is domestic issues involved with this case. He has been cooperative. As soon as he found out about the case, he contacted me, retaining a lawyer, and here we are. We plan to vehemently defend it. The supposed alleged victim doesn't even want to go forward in this case. That's the other person that was theoretically or alleged to be in this fight. And Your Honor, we have another case with Miss Sertich, Katie Sertage. We have reason to believe she's out of state. We can't even find her because we've been trying to serve her a divorce summons and complaint for the last 2.5 months. So, Your Honor, we know this case has a lot of holes in it. And Judge, as I said, this is not what it seems on its face. This is his in-laws' house. And he has gone in and out of that house 100 times since they have been married. And we are going to vehemently defend this case, Judge. And we ask that the court take all of this into consideration. He has been cooperative. He will go get prints. And, he's retaining a lawyer to defend in this case. And he hasn't shirked from any of those accountabilities. Thank you.
Can you remind me a little bit about this, Sergeant? I did the signing on record, and for whatever reason, I don't remember everything here.
So, Judge, yeah, we would ask for a PR bond.
Yes,
Your Honor, the complaint occurred on 5/24/25. The defendant is accused of entering into his in-laws' house where his estranged wife had been staying. There was a new guy there, and there was a physical altercation and an assault. It is true that the male in that, Mr. Jenkins, did not want to proceed forward with charges. However, the owner of the home, Sonny Lazars, did want to proceed with home invasion charges, and that's why he was charged. And so
So the assault was actually on Jared Jenkins.
Yes, the assault was on Jared Jenkins, but he invaded the home of Sonny Lazars to commit that assault, or assault committed while he was in that home, unwelcome.
What kind of conditions are you asking for?
So, Your Honor, based on the circumstances, I would ask that there's no contact with Sonny Lazars or Katie Sertage, and that the defendant cannot return to 21120 Dean Street. And I would recommend you consider a tether just for accountability purposes. That's the extent of the bond conditions that I'm asking for, Your Honor.
But you also don't want there to be contact with Jenkins, right?
Yes, Your Honor. No contact with Mr. Jenkins either. I apologize for that.
And Your Honor, if I may address, a tether is not necessary. As soon as he heard about this, he's retained me. And as I said, I'm on another case with him with respect to the divorce case. And Judge, if I may say so, as I've read the police report, even the person there who is his estranged wife, Katie, claims that she lived at Dean Street. And in the police report, even the woman, Sonny, that says Katie doesn't live here. Your Honor, there's a lot to this case. And that's a little off the rails. And honestly, he's going to return, Your Honor.
Okay. $15,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Sonny Lazars or Jared Jenkins or Katie Sertage. No contact with prosecution witnesses except through your lawyer. You're not to enter 21120 Dean Street in Brownstown. You're not to possess firearms. You're not to possess dangerous weapons. You have to go over to Brownstown Police Department, get fingerprinted and photographed today by 1 p.m. I'm not going to order a tether. He'll be sitting in jail for 4 days or however long it takes him. I filled out the order for prints. We'll send it over. Stay away from those people, sir. If I find out you're having any contact, you're going to have to pay a really high bond. Or you're going to be sitting in jail awaiting trial. Do you understand that, sir?
Yes, sir.
All right. Any questions?
Nothing for me, Your Honor. He'll be there getting prints right after this hearing. And we look forward to both being in court on the 2nd of September. And I thank you for that, Judge.
Have a good day. Thanks, Sergeant. Thank you, Mr. Bogart. Good luck, sir.
Thank you, Judge. You and your staff have a good day.
Yeah. Thanks. You have a case? Oh, yes.
One of the prosecutors have a case next door.
Oh, come on in. Come on in, how are you?
Yeah, believe that.
Yeah.
Nice to see you.
Yeah, I knew I recognized you when you walked in before. Come on back.
If you're I'm ready for Mr. Cobbs.
Yes, sir.
All right, let's go on the record in the matter of Nelson Howell. 241298.
Morning, Your Honor. Your Honor, John Goldwell, P 30758 on behalf of this fellow.
All right, Mr. Hupp, your name for the record, please. You're muted.
Oh, I'm sorry. Nelson Hope.
All right, thank you. Thank you for addressing appropriately. Listen, shots out there, we can see. Two things. One, your client is here for sentencing and his plea to an amended term of disorderly conduct. I don't see Kevin Hamilton or Jeannie Taggett here. However, the court would still proceed in this manner.
That's correct, Your Honor.
And there's also the request, was to handle this on the record as well, regarding use of marijuana while on bond. And counsel, as to the sentencing.
As the sentencing, Your Honor, you indicated use of marijuana while on bond. I'm not aware of that.
Well, so Mr. Hoke had submitted proof of a medical marijuana.
That's correct, Your Honor.
And he had one prior to the agreement that expired, so then he renewed it during the arraignment or during bond phase. And so my thought was that we would chat about that today.
Oh, okay. I saw that in the but I wasn't present originally. Fine, Your Honor. We've had an opportunity to review the pre-sentence report in this particular matter. Your Honor, this has been an ongoing matter. It's been a lengthy negotiations. This matter actually occurred back in September of 24. I reviewed the video of the arrest. I filed a request for the video of the incident, and we were informed that the actual video of his time at the McDonald's was no longer in existence. We've discussed his involvement in this matter and the reasons why this occurred. As to the general background information, as you can see, Mr. Houck has not had an easy life. Some of it is of his own doing. Some of it is because of the early stages that he went through. Ended up with the being excuse me, and I apologize, Your Honor. He's been diagnosed with behavioral problems, clinical depression. He had his parents never married, and he became a ward of the state at age 7. I'm sure the state did as best they could. However, as the court is well aware, that's not the best of all circumstances. He did complete high school. However, he did not graduate, and he received his GED. He also indicated that, and in here, that he has a paralegal certification. Trust me, my discussions with Mr. Houck, he's clearly learned a great deal during his paralegal training. He's indicated his health is decent. He's on parole, has been for approximately 3 years.
his parole officer is aware of all of this going on in his life. I did not speak with the parole officer, but I did carry on some other conversations with Mr. Houck regarding that. To be honest with you, Your Honor, and I know he wishes to make the statement, but as you can see from his statement, he was at McDonald's. He was there to pick up some food. That's why he was in the area. Things got out of hand. He felt that he was being mistreated. I guess one thing leads to another. And when you review the body cam, it's clear that when the officers arrived, he is attempting to tell them what really happened in there. Asking, hey, I need my witnesses. And they're just saying, well, no. And they're just responding and making an arrest, whether, rightfully or not, but he was. And you can see that what occurred or what triggered the incident in McDonald's. And I'm not saying he's not taking responsibility, but in his mind at that time, regarding whose fault it was or whose fault it wasn't, and as you can see from his statement, the long story short is I was in the wrong and I I think, Your Honor, that this all carried over. And so I know that the recommendation is for incarceration. He's had 3 children. He has a 4th on the way. I believe he's pregnant. And I know she's pregnant and she's due in about a month and a half. He is not employed at this point in time, though he is still going out and looking. As again, one of the things on his parole is, as he told me, for the 3.5 years, he hasn't violated his probation officer has not found a reason to violate, which is good. And I'm not suggesting. In fact, he's told me that he does not believe that he'll be violated for parole on this one. However, Your Honor, I'm asking that the court place him on probation. He does have another matter that's in the Langston Circuit Court. His parole officer is also aware of that. And as he's indicated to me, that's set for hearing, and they're aware of this matter as well. He's on probation. I'm not approaching, I'm bond out there. He's on a tether out there, and he's been in full compliance out there. I don't believe that incarceration at this time would be the appropriate remedy. He is the sole child care support. He's trying to get SSD. That's under appeal. And as he told me, what he's trying to do, Your Honor, is to, he also is attending mental health treatment, and he's trying to get better. He recognizes his past and recognizes that he cannot continue that way. And he's trying to move on. I don't believe that incarceration at this time would be beneficial to anyone.
Well, what would you suggest, counsel? Because the individual in this matter, well, first of all, the way that I would view the facts of this case is that Mr. Houck was dissatisfied with the time it took for him to be served or pick up a mobile order, whatever it may be. So he decided to then go behind the counter himself to get his food. Then proceeded, when an employee was attempting to prevent him from doing that, proceeded to assault that employee. Now, your client also, in addition to his lengthy criminal history going back to 2008, has a number of assaultive crimes. Currently on parole, and he's also out on bond on another matter prior to this matter.
That's an election. Yes, sir.
I understand that.
No, I'm just
But
saying.
for parole to not violate Mr. Howe based upon this incident and this behavior, and for a bond violation to not be occurring, I'm not sure if it's occurring actually. I don't know if that occurred. But also for a parole violation to not occur of the Lansing matter, I have serious concerns for the safety of the public and individuals in general, given Mr. Houck's tendencies for violent behavior. This was over a mobile order for food that Mr. Houck was tasked by his boss to go pick up. This matter was scheduled for jury trial. And quite frankly, the prosecutor at that time thought that it was in the best interest of justice to offer this matter, or this plea in this matter. And quite frankly, I don't see how I have a choice other than jail for Mr. Howe. Because the purpose of probation is to afford somebody an opportunity to learn from their behavior, fashion conditions to help them modify their behavior. I have zero rehabilitative conditions that I can offer to Mr. Howe. Zero. I have zero confidence in any of the conditions that I would typically put forward for somebody in a matter like this. That any of those conditions would be rehabilitative. At all. Mr. Howe, I am flabbergasted that you thought that it was your right to go back behind a counter of a place of business that you are not employed. And then when somebody attempts to stop you, you assault them.
Ma'am, can I speak? Are you asking me as far as opening the floor for me to speak?
Sure.
Okay, well, ma'am, I think you're misinformed on the incident that happened there. And that is why, if the video would have came out, it'd have showed the true actions of what happened there, ma'am. And I don't know where you're getting the information of. I was upset about how long it took or anything like that, ma'am. That is not accurate information at all. There is a police call. There was video evidence. You would have heard all these things if I'd have went to trial, ma'am. But the video was somehow lost. But 14 seconds of another video to show two heads bobbing in was found, which is a mind blowing to me. And I'm flabbergasted that justice isn't thinking, where is the evidence? Why was not evidence preserved at the time of a crime that you said you seen me commit from a video image? So why was it not preserved? That is the flabbergasted part to me, ma'am, that you are condemning me in your head already off of facts that are not true. There's like no factual basis for what you're saying, besides word of mouth. And anyone can write down their version of the story. Ma'am, and I know, ma'am, there's three versions of every story, but one version doesn't lie, and that's video evidence, right? And somehow somebody scrubbed the video evidence because they didn't want the truth to come out, ma'am. So
pause this a moment. I'm not going, I don't know, think they scrubbed that evidence.
the video evidence
Sir, if you'd like to make a statement that the video evidence isn't available or whatnot, you don't know what happened with the video evidence. I don't know what happened with the video evidence. I don't even get the ability to see the video evidence unless it's submitted pursuant to the rules of evidence. And since there were this matter that never was
love to go to trial.
Yes, excuse me. As far as where I'm getting some of that information, some of it's in your own statement, sir, regarding you were ignored for around 5 minutes. So that was in your own written statement.
Ma'am, in my written statement, I confirmed that I stood in line waiting. I stopped a different worker, not even the worker I got into an altercation with, ma'am. I stopped a totally different worker and asked a simple question of, hey, when does these numbers and I didn't say it with aggression. I didn't say it with irritation. I said, hey, can you please tell me when do these numbers transfer over to these numbers so I can get my order and go? I said, I already paid for the food. It's already done. And before he could even answer, the person who I got into the incident with came rushing over, intervened. What's going on here with an attitude? I didn't get an attitude back. I just explained the same thing to him, man. I showed him the picture I had. I showed him the screenshot I had that confirmed the order was already paid for, confirmed everything was done. I didn't even need to even come talk to nobody for real, man. All I had to do was be handed a bag and go, right? So I didn't go in here looking for an incident, ma'am. I did not. This is not like a
I didn't say you were in there. Sir, I didn't say you were in there looking for an incident. That's
No, but
not.
you said I'm in there violent prone, ma'am. You're trying to paint a picture in your words. You're trying to paint a picture of this big violent person. Ma'am, do you know how long it's been since I've been accused of a violent crime besides this one? It's been years, years. I have been working on, yes, I've had a violent past. Yes, I've had a history. Ma'am, I was taken from by the state at the age of 7. I was raised in placement homes and lockup facilities. I was never given a chance at true life. I was given the chance at being a caged animal. So then when you ask me, am I prone to violence? Yes, sometimes I do have what I'm diagnosed with, explosive behavior, ma'am. And that's only when pushed. All my violent record I have is assault and batteries. All those are from being locked up facilities, fights in a lockup facility. None of those are from street altercations, being in the real world altercations, ma'am. So I am not violent prone like you think I am. I was in a cage situation with other violent people, and situations became violent. Not to allow myself to be a punching bag to other people. Yes, and because I did more damage, I got charged, ma'am. I can't help that.
Sir, you're not out of Utah in 2018.
Yeah, 2018. How long ago was that, ma'am? How long ago was that? 18. This is 20. We're going on 26 now, ma'am.
Sir,
Years.
Sir,
Years.
it was you at the time of this incident that have been 6 years.
Right.
So
6 years since I had a violent outburst.
excuse me. That was aggravated assault resulting in serious bodily injury. Was that were you in custody during that offense?
Was I in custody during that offense? Ma'am, even on that case, there was never no evidence presented. I pled out because I was in prison for 3.5 years fighting the case already. So it just made more sense to go home, right? Take the deal that was offered to me and go home. And that was one of the cases on the deal. Ma'am, I didn't get caught on this crime at the scene. I got caught on, they reported this crime 2 months after this alleged crime happened. Ma'am, you're speaking on something you do not have the facts to, ma'am. You do not have the facts to these things. So you're still you're trying to justify in your head why you want to give me incarceration, which is not in the interest of justice to incarcerate me, because there are mitigating factors to this case that you are not even taking into consideration, ma'am. You're not. All you have said since you said something to me is about, oh, he's a menace to society. Ma'am, I did not go, this was not random. I was a working father at work who was denied his food because the color of my skin, and it was noted in the phone call that he made to dispatch. If you'd have heard that phone call when he said it's a black and he threatened my life, come quick. And I never once, in fact, threatened this man's life. In fact, ma'am, I asked him multiple times to take his hands off me before I even touched him, ma'am. Before I touched him, I asked him multiple times to take his hands off me. I informed him he was committing assault by putting his hands on me. Unwanted touching of any person is assault. He does not have the right to put his hands on me, no matter what you say, right?
Mr. Howard,
Yes, ma'am.
you entered a plea.
Are you justifying that he has the right to put his hands on me, ma'am?
Sir,
He has that right? Can you clarify for me so I have it on record, please?
that matter is not before the court for this court to make a determination.
What you're damning me about,
Excuse me.
Ma'am, I'm sorry. Give me the time you're gonna give me, ma'am, but I cannot sit here and let you lie on me and condemn me in your head as like this violent individual, and I'm not, ma'am. I'm not. I'm trying to change, and you're not even giving me the opportunity.
Stop interrupting this court. Stop interrupting this court. What now? Stop interrupting the court. This court has the information that it was provided after an interview was conducted between one of the probation officers and Mr. Howard. This court also has the criminal history of Mr. Howe and the statements of Mr. Howe, as well as the copies of the police report and statements of individuals at that time. Since there was not a trial in this matter, this court doesn't have the any additional evidence that may or may not have been introduced at trial, such as any body cam, any videos that may or may not exist or whatnot. And so this court is basing its ruling and its order for sentence on what it's previously stated on the record. Specifically, the information this court has as far as what occurred in this matter, again, based upon the reports and reviewing the statements of both Mr. Houck and the victim in this matter. And I think there was an additional individual that was named as a victim, but then indicated it was because they were trying to separate the individuals. This court's not making a determination as to who put their hands on who first. This court hasn't heard any testimony regarding that. All this court's doing is going based on the plea that was put on the record, the facts that this court has before it.
Ma'am.
Therefore, the court is going to, as I've stated before, the court does not find that there's reasonable grounds to depart on CL 769.5. The court does not find the probation will be beneficial to Mr. Houck. The court also is taking into account that Mr. Houck is currently on parole for a matter, as well as currently out on bond in another matter out of the Langston Circuit Court, Ingham County Circuit Court. And therefore, the court does not find that there would be any suitable rehabilitated condition for Mr. Howe to participate in probation on. Therefore, this court's going to order $45 days jail, credit for 1 day.
Ma'am, can I ask something real quick, please? As far as the credit timing goes?
You had 1 day credit served for the day you were incarcerated, and I was posted.
Yes, ma'am. Can I just ask you something? If not, it's okay. I keep my mouth shut if not, ma'am.
What's your question regarding your credit for time served, sir?
I also did 14 days in jail on this incident too, but that was through my PO.
That was for what?
That was through my PO. I went and turned myself in after this incident and did 14 days also through my.
You say you parole officer?
Yes, sir. Yes, ma'am.
Okay, so that's on that data. So there's that. I'm not affording any credit for time served on this shit.
Right. If it's due to this matter, that's why I was wondering.
I understand that. That was as a parole violation, so the court's not.
So that was a parole violation then?
Yeah, I did get violated for this incident and the other incident. I've done 14 days on both of the incidents I caught. In 3 years, I've only gotten in trouble twice, which is an outstanding job for most people on parole.
Okay,
I wasn't.
Okay. The court's going to do the 1 day credit for time served, and the court's also going to order restitution if requested. As of this point, it does not seem to have been requested, but there may be a request.
And then if he has a right to, we can have him.
Of course.
So it's.
All right. As relates to your date to report, sir, the court will give you until Friday to report. So you need to email into, Ms. Shine, so she can give you the information regarding that report date and how to report and what
I
to.
believe this was,
I mean, Ms. Shine, did I say short?
no, you did say shines, but I believe this is Mr. It says Mr. Shaw.
Oh, Michelle, okay, either one in the probation. And then also as it relates to your medical marijuana card, you have something in here from a cannabis doctor. If you're been asked for a treating physician. And then the question I had was because it says that you didn't have any, you were out of your doctor's care and not taking any medication this time. Given that this court's not placing you on probation, the court doesn't find the need to continue to, exhaust that issue.
Thank you, Ron.
Is that it?
Just make sure you email Ms. Shaw.
Okay.
Good
So
luck.
I'm done now, though.
Yes, you're all set.
Oh, time on Friday because my fiance doesn't get off work till like 6 on Friday.
Great. Smarter sign, you gotta be email the shine, email her at 12:45, so communicate all with us. Okay, sir?
Okay, and then so I'm done, right? I'm done and passed down, right?
Whatever, and if you want to heal it, simply want to heal.
Well, at this point, I'd just like to say that your fucking court is a joke, and you are carrying your fucking self.
Sir, you are on your word, and this is a court of law, and that's unacceptable.